Good afternoon, ladies and gentlemen. My name's Ben Flynn. I'm the CEO of the Geelong Chamber of Commerce, and I'd like to welcome you all. We've had over 250 registrations for our HR Essentials webinar today, so welcome. I'd like to welcome also Martin Reid, Head of Workplace Relations at Coulter Roache. Welcome, Martin.
Thank you very much, Ben.
Sue Kelly, Principal at HR for Business. Welcome, Sue.
Hi, everyone.
Thomas Fuimaono-Page, Industrial Relations Specialist at the Vicotrian Chamber. Welcome, Thomas.
Thanks, Ben. Great to be here.
Fantastic to have you with us today. I'd like to also thank the Chamber corporate partners, especially SC Technology, our platinum partner, for allowing us to be here today. And thank you to everyone for supporting our webinar, our third webinar in our series. Can I start by asking you all, and I'll start with you, Thomas. You've been with us before a couple of weeks ago. How has your last 2 weeks been?
It's been very interesting. Certainly moving out of the office and into the home. I've got the setup at the dinner table at the moment. I've got my wife working upstairs in a I guess virtual call centre. So it's been very interesting. It's been very busy, getting a lot of calls and emails from members. But largely it's to do with COVID-19 and how to deal with all these sorts of things.
Yep. And Martin, how have you been finding it locally
over
the last couple of weeks?
Slightly different experience for us, Ben, because as a staff of roughly 75, we've got about the vast majority of them working from home, the lawyers and even some of our assistants working from home. We still do have some of the support staff and some lawyers working in the offices because we can comply with government regulations by doing that. So I'm still in the office here in Geelong, is where we're speaking from. So from that perspective, it's been quite strange. I tell you, it's been an interesting ride for me coming in from Janjuk every day. That the old Geelong Road, or as it's now called the Surf Coast Highway, is quiet. I can get into Geelong in 25 minutes rather than the 45 minutes. So it does.
Martin.
Very good. And Sue, how have you been finding the response from your clients over the last couple of weeks?
We've been actually quite hectic, Ben, in relation to responding to clients and new clients at that, people that we haven't dealt with before. And in addition to that, we did maintain our presence in the office up until this week. Because we're like Martin, there's 4 of us in the team, but there was enough space for us to maintain those social distancing rules. But yeah, just moving a team to home, fielding the questions, responding to the clients, engaging with the team. Like most other people, I think it's been quite a challenge. But this sort of setup with Zoom, which I know a lot of people are using, it's been great. So I'm checking in with the staff at least a couple of times a day on a Zoom basis.
Yep. Now, to all of our participants, I'd like you just to have a bit of a look. You can write questions to me that I'll ask the panel. So please feel free as we move through, and I'll do my best to get through some of those questions and clear things up. Now, Thomas, obviously the elephant in the room in the last week has been the wage subsidies. I suppose the Victorian Chamber phone lines have been ringing hot.
Absolutely, they have. The discussion has very quickly changed from job seeker to JobKeeper and how those payments will look, which is fantastic. And I guess it's important to note there are a range of funds and subsidies out there. The Victorian government announced a business support fund. So do check out the Victorian Chamber website. There's information there. I suspect there might also be some information on the Geelong Chamber's website, but certainly the elephant in the room is the JobKeeper payment. We're really happy to hear about that. $1,500 a fortnight will go a long way to keeping a lot of people employed, but the legislation still has not been written. So there's a lot of questions out there that we're hoping to get some clarity on in the coming days. The Australian Chamber of Commerce and Industry, in conjunction with a number of other changes, sent a long list of questions to the government last night to have answered and to consider when drafting this legislation. But it's going to be very interesting to see how it's implemented and how everything will work. One such question is whether employers should be paying employees who have been stood down or who aren't working $1,500 a fortnight right now on the presumption that that will be refunded to them in the future, or should they wait until the payment actually is activated in a few months' time. There's also various questions about the government's suggestion that people who have recently been retrenched, that they be re-employed. There's questions such as, can you recoup redundancy payments? Is this a new form of employment? How about continuous service? There's a lot of grey areas out there which we're hoping will be clarified in the coming days.
Now, help me out here, Thomas, for our participants' benefits. But the wage subsidy is effectively $1,500 per fortnight, which is taxable in the employee's hands for any part-time and full-time employees as of the 1st of March. Now, they don't need to have served a 12-month period, and casuals who have served 12 months as at the 1st of March. Is that correct?
Yep, that is correct. And I guess it's important to note, especially for the casuals and part-timers, if previously they were paid $1,000 a fortnight, they will be getting a pay increase, despite the fact that they won't be working more hours to earn that. So it's a bit of a win for some of the lower paid individuals out there.
Very good. Very good. And Martin, have you been advising clients this week? So what the other big elephant in the room, and I don't know if the wage subsidy changes things, but there's all sorts of conversations around and examples of employees being stood down, reduction in wages. Have you noticed any of this, whether that's more broadly nationally or locally?
Well, it's an interesting subject, because this is a brave new world for us, but also the Fair Work Act. The Fair Work Act has a provision in there for stand downs, but it was designed as a temporary measure for circumstances where, say, an employee's business was flooded or there'd been a fire. It wasn't really designed for a long-term epidemic like we're dealing with now. So the lawyers in this area are grappling with this as best they possibly can, but I think there's a real distinction that needs to be drawn here between what is a stand down of an employee and what can be the lawful stand down, and also then what can an employer do in the circumstances where they can't stand an employee down because there hasn't been a stoppage of work. So they're two separate things, and I think at the moment employers are the ones that I'm speaking with are grappling with that distinction about whether or not they can stand people down or not. Now, at the risk of going into a long dissertation about the law, it's certainly not entirely clear where that line is drawn. But I think the best way to think of it for the employers out there listening is that there needs to have been something that's outside of your control. So it's generally a direction from the government, perhaps, that means that the work is actually stopped. So if it means that, an example for the client, I have a client whose business involves very close interaction from their staff with their customers. So they've effectively closed their stores because they cannot do so. Otherwise, they'd be in breach of the social distancing laws. So in that circumstance, she's entitled to close down a business and stand her employees down. Where other customers can have something that they've got, the clients have a problem with, they've got a reduction in their economic uptake. So, for example, a car yard, for example, all of a sudden nobody's kicking the tires anymore. That doesn't give an employer the right, though, to stand an employee down, because that's the economic impact of a decision rather than the actual stoppage of work. So it's a real distinction that needs to be drawn.
Ben, can I just make a comment there? And just for Martin and Thomas's purposes as well, which might be one that comes up. We had a client who the nature of their operations, they haven't been asked to or haven't been required to close. What they have done is move their substantial workforce to work remotely. And the one position, which is a reception role, there's nothing for that person to do. So they spoke to us about, can we stand that person down and enact that piece of legislation? And we advise no, because effectively the business is still going. But and this person happened to be only 6 months, less than 6 months anyway, but in that was one where it was really just because of the model that they chose to take. They could have remained at the office and they could have had someone there, but they actually then found some other work for her to do, and she hasn't been stood down.
A couple of questions from the panelists, if you don't mind. One question was, would full-time and part-time and casual staff still get paid $1,500 if they've traditionally worked less than that? Now, Thomas, my understanding is that if you've been getting $1,000 a fortnight, you now get $1,500. That's
correct. Same deal for permanent or full-time employees or individuals who earn more than $1,500 a fortnight, presuming that the employee continues to work those hours and perform that role, then the employer will have $1,500 worth of that wage provided by the government, but the gap between the $1,500 and the ordinary pay will obviously have to be funded by the employer.
Is that presuming they're still working, Thomas?
Yeah, so presuming they're still working, presuming they're still earning more than $1,500, if they're lawfully stood down and they're not performing any work, then naturally they will just receive $1,500.
Yeah, that's one question that we've been asked as well. It wouldn't make sense to pay someone for work they weren't doing.
The other one that I've been dealing with, there's the Chamber as a small business as well, is that you need to prove a 30% reduction in turnover, and whether that relates to the previous month or this month last year, how do we go about that? And we're still trying to establish that at the moment. That's fair to say, Thomas and Martin?
I think sorry, Thomas. I think it's almost impossible to tell, as Thomas said earlier, what the legislation will actually say, and more importantly for the employers out there who are thinking about making the payments, whether or not it will be retrospective right back to the 31st of March, even if you can't demonstrate you've lost 30% of your business up until June, perhaps. Because I'm a bit, is the government suggesting that you need to have got to a position of crisis before it will come in? Or will it simply say that once you get to that point, we accept you're part of the system and we'll pay you right to the very beginning of the system's implementation? So we don't know the answer to that question yet, because all we have is a press release more than anything else. So until such time as we see some legislation, we don't know.
Marie from WMC Accounting, who's online, has said that there is a Treasury updated fact sheet today that we encourage people to look to. We also encourage people to register via the ATO for the JobKeeper allowance too. That's an important start.
Yep.
Another important issue that people are grappling with, and we've touched on it slightly, is working remotely and how we ensure the well-being of our staff during this period. Sue, is that something that you've been discussing with clients?
Yeah, I mean, clients are obviously concerned about maintaining their staff. They're concerned about their mental health. Some people enjoy being in a team and being around others. And it's also, there's also been discussion around productivity because and lack of visibility. And there's a great degree of trust, isn't there, in these sort of circumstances? But I think, as I said earlier, the checking in with employees on a regular basis, keeping up the communication, whether that be online. A lot of businesses these days operate with Microsoft Teams. And that's a great tool. Other than Zoom, if anybody is on the Microsoft system and hasn't got Teams installed, I highly recommend that because you can not only talk just sort of online, but you can talk, visually to each other. And the other thing that I would recommend is, make sure people are comfortable in terms of their seating arrangements. Get your chair from the office if need be. I had to make a mercy dash the other day to get my chair. I had one at home, but it wasn't quite cutting it. Our OH&S policies are, working from home policies. We've developed a working from home checklist arrangements document, and that covers a whole lot of items for the employee to tick off. Yes, I will. I have got a suitable setup. I am going to be sitting ergonomically. I understand that I need to notify the employer if this happens. and it just sets out expectations in these times, which are a little different to the norm.
I'll just, if you let me jump in there, Ben. I've seen both from our perspective at Coulter Roache and also from my client's perspective that we've tried to accommodate a particular employee's requests. That some particular employees don't want to come in at all. Others want to actually come in rather than work from home, and so we've tried to accommodate that as well. So rather than having a straight direction, you must all work from home. Instead, we've been as open as we possibly can with everybody. But we've also probably increased for a lot of teams anyway, a lot of the communication between each other, because we have a scheduled meeting every day. Each team within the Coulter Roache family has a Zoom meeting where we sit down and talk to each other. What have we been up to? What are we doing today? And we have some jokes that go into the meeting as well, because we are really concerned with especially some of the younger staff who are at home by themselves in a room with a computer, and that can be quite isolating and deleterious to their mental health. So we're very conscious of that. And I spoke to one of my solicitors today, and I said, look, by all means, if you want to come into Geelong for one day, if you want to, that would make you feel more connected, please come in. So there's a real concern out there for people working from home. I haven't experienced it yet, and perhaps for older people we'd be more comfortable with it, but for a lot of younger people it is very isolating. And just to go on one more thing that Sue mentioned, sorry, I don't want to take your airtime up, Thomas, but a lot of people need to understand as well, and that employers perhaps don't understand, that all of their occupational health and safety obligations continue on when the employee's working from home. And obviously some of the people will remember the case of Hargraves and Telstra, which is where a woman fell down the stairs at her home. She had a sneezing attack and fell downstairs when working from home and broke her collarbone. Yeah. And that ended up becoming a compensable injury under the Commonwealth Workers' Compensation legislation, because that was effectively deemed to be the place of employment for the period of time. Now, they didn't suffer an investigation from a relevant occupational health and safety regime within the state, but you could as well if you're an employer in situations where you've got somebody at home, and as Sue said, they've got set up on their dining room table.
Thomas.
And they end up with a bad back. You could find that WorkSafe would come and investigate you, as well as not only do you have a workers' compensation issue, you've also got a claim from WorkSafe against your business. So employees need to be really conscious of all those things as well, that out of sight doesn't mean out of mind.
Yep.
That's right. Yeah. And duty of care continues, doesn't it, Martin?
It does.
Very true. Very true. Now, a lot of our participants are still interested in the detail going around. And something we haven't touched on is COVID-19. People being tested positive, or even if they choose to self-isolate by their own choice. Thomas, from a leave perspective, how do employers handle that?
Well, I guess, ultimately it comes down to the reason why someone's seeking leave. Obviously, if somebody tests positive, then they should be home and entitled to paid sick leave. Likewise, if the employee is suffering just a common cold, they should be on sick leave too. If an employee has been directed to self-isolate, but not necessarily tested positive to COVID-19, some bodies are recommending that individuals should be entitled to paid leave. We don't believe that is the correct construction of the National Employment Standards. You should only be taking personal leave if you are ill or injured, or if you're providing care or support to an immediate family or household member who is ill or injured, or due to an unexpected emergency affecting that member. Not if you are isolating, and not being actually not having tested positive. There are other considerations to make, such as the employee's mental state. We know a lot of individuals are saying, I don't feel safe on the tram, I don't feel safe on the train, I want to stay home and ensure that I don't get sick or get the virus. That's going to be a difficult decision or discussion to have. at the end of the day, if you refuse such a request and compel the employee to perform their job, which in many cases will be reasonable, it's likely that the employee could get their hands on a medical certificate stating that they're too stressed, suffering too much anxiety to perform their role. So any discussion about leave should be handled with care. And now more than ever, it's so imperative that employers make sure that they get it right, so that they're not having to deal with an underpayment of wages claim or a back pay claim in the future.
Now, Fairwork.
Sorry, can I just also add that a number of awards, I think 103 of the awards, are about to be amended to introduce a pandemic leave provision. And I think that's designed to get around some of the things that Thomas just talked about, which is what does an employer do in those circumstances? So instead, it doesn't really create a right for an employee in any respect other than they can be away from the workplace for a legitimate purpose. Ultimately, I think it's best described as providing a workplace right so that an employee can bring a general protections claim should an employer take a decision to terminate an employee because they decide they don't want to come in just because they're nervous in the circumstances that Thomas just talked about. That ultimately doesn't mean anything other than they've got a right to say, I'm entitled to stay home for 2 weeks, which is what the provisions of this new changes will mean, because I need leave because I'm either worried about the coronavirus or I think I might have it, or any of those things. So when that comes in, that will change the landscape a little bit.
And some other recent changes in awards. Martin, you and I touched on these earlier. I know we thought about restaurateurs and clerks awards have changed, and even to reduce people's hours now, you need a 75% vote among your staff.
Yes, and I think that's, you know, a lot of employers be quite naive to some of these particular rules in their awards. And so at the moment, they said there's the hospitality, the clerks and the restaurant industry awards have been amended. And effectively what they've said is that the direction, that there's two main amendments. One's been you can direct employees now to take leave as long as they've only got 2 weeks up their sleeve, but it used to be 6 weeks. Now this is direction, remember, I'm not talking about agreement between employer and employees. So that's an important distinction to make. You can agree with the employees to do something else, but I don't know whether employers realise that you actually have to comply with the award. But more importantly, as you said, reduction of hours is much more stifled. It's basically before the award changes that are referred to, and there's only 3 awards at the moment. You couldn't really reduce an employee's hours at all. And so now they've created a system, much like an enterprise agreement system, where you sit down with the majority of your employees, and if you get a majority of your employees agreeing to it, you can reduce their hours by 25% only. Now,
that's been done in the last 2 weeks without that update, Martin. So there's been people who, I think a lot of us were getting the information that as long as you talk to your employers and that you're fair and honest about it, then you could proceed to save your business.
Look, I think there's a distinction to be drawn here between what an award says, because it's a system, it's a blanket system that, you know, drafted by lawyers for the unions and the employers to say this is in the circumstances where you don't have a relationship with your employees, you need to understand these basic rules and regulations. Now, I'm not suggesting for a second an employer should breach the award, but the same circumstance, if you're a small business with 2 or 3 employees and a conversation is had and, you know, reached between 3 or 4 people there and say, look, this is what we need to do, I don't think the Fairwork Commission is going to be calling you in front of it saying, why didn't you follow these formal steps? In circumstances where it's quite clear, and it would be written, that the employees have agreed to it under the circumstances.
Yeah.
We've had a client. I'm just sorry, Sue, go ahead.
I was just going to say, we've had a client who their staff are award free and they're paid well above any minimum requirements, you know, the national minimum wage. All those people have taken a 20% pay cut.
Yeah.
There was a discussion, like, although they're award free, there was a discussion with the cohort. They agreed for the want or the better of the business and maintaining all of those jobs rather than make 1 or 2 or 3 people redundant. That's what the cohort agreed to do. And I guess, you know, what Martin's saying, we've had discussions with clients around, you know, talk to your staff. Some people's situations are different. Some people will be amenable to making changes. And as long as you agree and you document that, I think that that's a fair and reasonable action. It's with the view with the maintaining that person, isn't it? And then, if you are then entitled to the JobKeeper down the track, you can up their hours and get the offset, if you know what I mean, or they'll get that minimum payment anyway.
And you touched on it, Sue, but what sort of documentation or audit trail should employers be keeping about these discussions and actions?
We've recommended minutes of meetings. Don't just call everybody, hey, at a whim, send an email out, advise that there's a meeting, the reason for the meeting. Do things as you would in the consultation clause as of an award, even where the employees are award free. Then with each arrangement, obviously talk to people separately because there's confidentiality around that, and some people might have different personal circumstances. But where the agreement is made, there's a letter which states obviously the person's name, the reference to the discussion, what's occurring, the duration, and there's a signing section in there for the parties to actually sign, and that's been agreed. And that goes on obviously on their HR file.
So keep good records.
Yeah, well, we would refer that anyway. And there is one other thing that I was chatting with Martin yesterday, and he might like to elaborate on this one, which is a question, I don't know whether you've had it, Thomas, that we've had from clients. If we're standing, we need to, as per a government directive or the like, we have the ability to stand people down under the, provisions of the Act. Then the employee says, can I take my leave? I've got, 6 weeks of long service leave, or I've got 5 weeks of annual leave. The question has been raised, am I, as an employer, obliged to approve that leave? I mean, I know it's leave by agreement, and what is unreasonable. And Martin and I had a discussion around this yesterday. And I think, Martin, if you were to explain your viewpoint on that, that would be really beneficial for the audience.
Yeah, well, again, Thomas, I'm happy to hear your view as well. But from my perspective with the Fair Work Act, it's quite clear there is no obligation upon an employer to pay annual leave in the circumstances or long service leave or anything else. And I think the reason for that is it's the intention of the legislation at the time saying you're under financial duress, which is why we're giving you this ability to stand your employees down, because that's an incredibly powerful weapon, as you can imagine, as we're understanding somebody being told all of a sudden they don't have a job. So what the law recognises is it's only applicable in times of acute financial distress. And so it would undermine, in my view, the purpose of the legislation if employers were then required to start forking out perhaps tens and thousands of dollars of annual leave payments or long service leave payments when they're suffering the acute financial distress.
So just so I'm clear, Martin, employers can stand people down who have leave in their accounts, and so employees effectively are forced to take unpaid leave because they can't access their provisions.
Yeah, it's not. That's right. It's my understanding of the law for the reason I just explained. It's not. I mean, I'm not suggesting it's what employers should do, but they could certainly talk about half pay or those sort of things to ameliorate the situation. But I think it would end up defying the logic of the legislation if you send employers broke by asking them at a time when they have no income to start dipping into their bank accounts to pay people's annual leave.
Now, we've only got 2 minutes left. I'm sorry, Thomas, unless you want to really add something to that.
Yeah, look, I thought it's just important to know, certainly I agree with what Martin and Sue were saying. The Act does specifically say that if an employee is on annual leave or long service leave during a period of stand down, they are not on the stand down while they're on leave. So there are provisions for people to take leave. And I think at the end of the day, it does come down to, as Sue was saying, the reasonableness of the request. An employer can certainly deny a request on pay provisions if they can't afford it. But if they can afford it, then they probably should allow the employee to take leave.
Case by case base. I mean, I kind of thought to myself, if it's a small amount of people in a big workforce, that might be unreasonable to say no. But if your whole workforce, that's a different kind of matter. But
the other big question I have.
Very quickly, Ben. Sorry, that just
I'll
poses
carry on if you don't mind, Martin. The other big question I have is that we will come out of this, no doubt about it. So employers need to have a ready workforce, unless they feel like recruiting their whole workforce again when we do come out of it and open up. What advice, just going around the room really quickly, given we've only got a minute left, what advice would you offer employers in short?
Employers. Go for it, Thomas.
I was just going to say, I think it's incredibly important for employers to just keep those communication channels open, keep employees engaged. Obviously, it's not going to be as easy as it always has been, but continue to engage with your staff, continue to update them on the circumstances, continue to look to the future, and provided you can continue communicating with your staff and keeping them engaged, then ideally, when we start to come out of this, then it'll be, very quick sort of transition from working from home back to getting in the office and getting back to doing what we've always done.
Very good. And one last question, yes or no answers, I think, from one of our guests has asked us, if we were looking to undertake a restructure prior to COVID, would it be safe to continue?
Well, I think it's would be safe to continue. You've got this valid reasoning there, and take it all into consideration. Follow the right process. Martin,
I think
Thomas?
it's a yes from me.
Yep.
Yep.
So thank you, everyone, ladies and gentlemen, for joining us today. I'd like to thank our guests, Sue Kelly from HR for Business, Martin Reid from Coulter Roache, and Thomas Fuimaono-Page from Victorian Chamber. Thank you, everyone,
Thanks,
for joining
Ben.
us. And thank you,
Thank you, Ben. Thank you, everyone.
I should say that a lot of our participants have said that a lot of your information is spot on and really, really helpful. I know we could probably talk for hours, but thank you, everyone, and good luck with your businesses.